Good afternoon, madam.
Can you start, sir?
Yes, madam.
Good afternoon, sir.
Good afternoon, sir. Good afternoon, sir.
Good afternoon, everyone. I welcome you all to the
Madam,
podcast
your voice
of
is low.
Series 19.
Your voice is
So, in
low.
the topic Best Practices During CIRP Part 2, now I request her to start the session, please.
Okay. Sir, good afternoon to all. Today also, the best practices. And if best practices, am I, am I audible, madam?
दोबारा सुनाओ नया
Yes, you are audible.
दोबारा से फ्रेश सुनाओ ये पूरा
Okay.
फ्रेश वीडियो बेकार गाना सुने ताकि ये तेरी भी फीलिंग यही रहे
music experience.
अभी ऐड खत्म होने दे
Any order. Tap the banner.
Okay.
जब से
So,
13 साल की है
अरे,
क्लाउन डॉल
some voice is coming.
की तारीफ करने लगी वहीं दूसरी तरफ फिर मेरे को सीरियल खेलने
सब जो है बेटा
पार्क में क्लाउन जैसा
साथ में तो साथी आएंगे ना
एक ना से हर जगह ढूंढा गया
Okay, sir. Now, yesterday also I discussed about during pre-CIRP, during CIRP. Today, if at all best practices are not followed, some problems will arise, including disciplinary actions also. Because here we have to show the quality of the CIRP process. And if at all quality is missing, then some bad results will come. In computers also, one the quotation is GIGO, garbage in, garbage out. Garbage in, garbage out. So here, being a professional, we have to show our talent, we have to show our skills, we have to exhibit our knowledge. All these things are there. Today, I will discuss about during CIRP, what are the issue, what are the solution, and if it is not properly addressed, what are the penalties that are imposed by IBBI or judiciary authority? That also I will discuss. And if the IP is not followed the best practices, whatever the steps are there, the steps as per the laid down norms, we have to fulfill. If it are not fulfilled, then we have to face the consequences. So for that also, I have taken one case study, that Akruti case study also. And all these things up to 5 o'clock I will discuss. Tomorrow, the last class, that is the best practices, the post-CIR. Post-CIR. How to overcome the challenges? Challenges are inevitable. Some challenges, if at all we are having knowledge, challenges is very easy to overcome. If at all some knowledge gaps are there, definitely the challenges will become a problem. That's why we have to face the challenge. We have to overcome the challenge with the help of knowledge and strategic thinking. Knowledge and strategic thinking. If at all we are well versed in the particular IBC code or regulations or judicial pronouncements, definitely during the course of the CIRP, definitely some good results will happen. Overcoming challenges. What are the challenges? delays or problem caused interim resolution or resolution during CIRP and IBC primarily include leveraging legal mechanisms and a supervisory body established code and adjudicating authority NCLT and IBBI we have to follow. If at all we have not followed, then it will be a problem. Whatever the guidelines, whatever the stipulations that are mentioned, the common challenges, particularly in the resolution mechanisms, are negligence of duties. Some of the IPs, they are taking this CIRP project as a casual manner, not in a serious manner. Once that is given the assignment, we have to involve in that assignment. Some of the people, particularly some of the IPs, due to various other engagements, other professional, particularly professional areas, they are not giving attention or concentration on this area. Thereby dilution takes place. Once the dilutions are there, definitely some side effects will be there. Negligence of duties, that should not be. That's why IBBI has issued one circular also. What are the common mistakes that are done by the particular IPS during CIRP process? Lack of impartiality. So, lack of impartiality. So, you should not give some favor to somebody and not favor to others. All are equal. The last person, whether it is a worker or any other, you have to give attention. Attention means I am not talking about give the lot of time, but you have to listen the workers, whatever their concerns are there. Employees' concerns, particularly the operational criteria concern. If home buyers are there, home buyers concern. The financial criteria, both secured and unsecured. At the same time, the problem is the corporate data. Who runs the business for a long while and hand over the business to you? So that's why lack of impartiality. Excessive delays. Why excessive delay? Why not on time schedule? Suppose I take, for example, problem arises. For every problem, certain solutions is there. Think the solutions and use the best among the alternatives. Now, if at all problem is there, keep quiet means, suppose I take, for example, liquidity problem is there, or money is not there. So, whatever the unencumbered assets are there, mortgage it, take the amount, use for CIRP cost. Today, even the financial creditor is with you only. He is one of the member of the COC. You discuss the matter. If at all this unencumbered, the CIRP cost during CIRP, whatever the amount you have borrowed, that is the top priority. So that's why the financial creditors also, you convince, otherwise there is no use of filing the application by the financial creditor or operational creditor. So the excessive delays should be avoided. Claims. Why pile up? Today 10 claims are there. Verify with the help of the staff or the financial creditor submitted or operational creditor submitted the claims. On the day one, you verify. Some of the people, okay, let them come all. Then later on, is it a tender system? And the closed covers have to be kept. The claim. If a claim is submitted, open that claim, whether it is our eligible claim or not. If not, return it and write it on a book. Why you have written? What is the reason? Document it. Later on, if at all these people are approached the courts, then we will give that answer. So the excessive delays have to be addressed. Failure to maintain transparency. Sorry, today RTI Act, Right to Information Act is also there. Why they hiding the nature? Because you are also the third person. You are also the third person. Whatever the disclosure agreements are there, disclose. It is not a confidential one. If at all it is a transparency is more, then some solutions, some problems will also arise. But the failure to maintain transparency. Some of the people, they are hiding the information. They are giving the wrong information. Again, I am telling, go garbage in, garbage out. Non-compliance of IBC regulations. Once you have passed the tough examination, and daily you are reading judicial pronouncements, and in the group also you are understanding the various issues. What is the problem in addressing that one? So it is not a rocket science. The code is only one book. Not a different acts, you need not refer. The code only 252 or 256 sections are there. And the regulation, CIRP, only one regulation. That too, they will update from time to time. Once you read, later on, only updations you have to update. So, why non-compliance? What is the problem in not complying the stipulations or regulations defined by the regulator? So, challenge problems, applicable mechanism, and a description. Failure to act impartially or maintain independence. Application to the adjudicating authority. Stakeholders can file the application with the NCLT to question a resolution professional conduct or and request to their replacement. Why that problem is arise? That is on account of the RP only. So, impartiality, failure to act as an impartiality, no partiality, or maintain independence. If at all you are not doing favor to certain people, not doing the other people, then the same problem. Application to the adjudicator, definitely. If at all I am the operational creditor or the financial creditor or the home buyers, if at all you are giving a lot of preference to the secured creditors and neglected me, definitely I am the aggrieved party. Definitely I will file the case with NCLT. Excessive delays in CIRP time limits or failing to meet the deadline. Sir, once you have started the work, what is the next step? What is the next activity? What is the next the job or process? Like that, if the thinking process is on, definitely good results will happen. Once public announcement is given, aram say you are taking the leisure time means no. What is the next step? What is the valuation? What is the puff transaction? What is the information memorandum? What is the expression of when I have to give? And when what is when I have to complete the COC formation? One by one, up to last event. You have to think daily. Up to last event, you have to think daily. So that's why whenever I'm giving lectures, I told that CIRP is a event management. Event management. So the events are clearly defined. That events are time schedule is also there. So today, everywhere, event management to meeting the political party to the conduct any the college event, any event management and the distribution of work, delegation of work, extract the things from the people. So that type of the activity is required. Monitoring the committee of creditors and the NCLT intervention. If at all delay is there, sir, that RP is not doing well, sir. Please replace that one. So the stakeholder is having a right to approach NCLT or IBBI also. Even some of the stakeholders, corporate debtor is also a stakeholder. So if at all in the liquidation, he will get the lost person is the equity shareholder, before that preference shareholders. The COC actively monitors the progress. Now today, the financial institutions, they acquired knowledge because they are handling so many CIRPs, COC meeting. They are always compare with the other CIRP, whether Mr. Prasad is doing, he is a good person, or whether he is having knowledge, or whether he is going to complete the CIRP process, whether he is addressing whatever the challenges are there, all are witnessed or observed or audited by the financial creditors, those who are the members of the COC. COC actually monitor the progress. And if RP is cause a delay, if at all you are doing intentionally, COC can vote for the replacement or request for NCLT intervention to issue the appropriate direction. Leave it of the COC, sir. Even NCLT is also bombarding some of the RPs. In that case, what is there? Nothing is there, Bhaiya. Why you are delaying that one? Do you think that if a delay is there, you will get a honorarium? That type of questions are also. I am the eyewitness. In the court hall only, they are telling like that. If that is the same is happening next also, you are not addressed that issue, definitely I will communicate the same to the IBBI. So that type of a situation should not arise. So the best practices means it is not defined elsewhere. Whatever the code, whatever the act, whatever the regulation, whatever the rule, whatever the judicial pronouncement, judgment, implement that one. That is nothing but a best practice. Best practices means need not be copied from other developed country like UK or Singapore or the Australia or USA like that. Non-compliance with IBC provisions or related regulation. Compliance to IBB, disciplinary action. Today, the disciplinary action is initiated by IBBA. Almost every month, one IP, they are cancelling the certificate of a practice. The IBBA, the regulatory body for IPs, investigate the complaints. They don't keep quiet regarding the professional misconduct or breaches of the code. They don't keep quiet. No. These people are doing complaints. They are even in the banking system also. The ombudsman is there. Insurance also, ombudsman is there. Like that, the particular stakeholders, they will send that information to IBBA or they will file to the NCLT also. Once the complaint is there, definitely they will look into lack of transparency or refusal to provide information to stakeholders. What is the problem? Suppose you are inviting the corporate data for the meeting. He is listening. He is whatever the discussion, no confidentiality. Because once he is in a COC member without voting, he will listen. What is the problem in providing the whatever the agendas or minutes are there? Otherwise, he will approach it because the baby is first belongs to corporate data only. Later on, it is going to handle by us only. Application to the adjudicating authority and the COC oversight. COC also they are auditing your, because they may not tell. They will always audit your work efficiency, how you are planning, how you are addressing the issues. The COC has significant powers to demand information and reports from RP. And the adjudicating authority can issue orders complying the disclosures. Once the complaint is there, the adjudicating authority also give a lot of attention, importance to the complaints. Once I am transparent, once I am following the regulation, even complaints also, I need not bother. Even the adjudicating authority asked, I am giving the proofs of steps to overcome challenges. What are the various steps to overcome the challenges? Stakeholders, like creators are there, operational creator, financial creator, class of creator. Not only that one, the home buyers, the committee of creators, the corporate data management. All these are stakeholders can take structured steps. Sir, once my company is taken, they handled by you, definitely I am 100% auditing your activities. If at all inside COC is there, inside you are there, definitely I will closely monitored like a CCTV camera. The corporate data, the financial creator, the operational creator, or the home buyers, or the others, they are always observing the moments of the resolution profession. It is like a CCTV camera. So that's why we have to do the best to the company. And engagement and communication, initial step. The first step usually address the issue directly with the IRP or RP through formal communication. If at all any complaint is there, first it will come to you only. Sir, this is a complaint. Please address it. If at all you are not address it, then I will approach the appropriate person. So at that moment only, you have to address that issue. If at all it is delayed, then it will be a big problem, Often simply miscommunication or oversight can be corrected this way. Okay, if at all any miscommunication between that complaint person and you, then address it. Then it will automatically smooth the sailing of the corporate insolvency resolution process. For the smooth sailing, the complaints are to be addressed at the root level. Okay, complaint. Oh, no, I don't have the time. No, I don't want to listen now. I'm having so much work. Means thereafter, this complaint becomes a big problem or challenge during the course of CIR. If they are unresponsive or problem persists, escalate to COC. If at all you are not addressing the problem, whether it is a financial creditor or the operational creditor or the corporate debtor or any other person, the home buyers, definitely they will address it to COC also. So we should not give a scope to that level. Second level, it should not go. The first level only that is to be addressed. The first level only should be addressed. Next, intervention. Once you have not addressed, the second level is a committee of creditors, they will approach individually. Whoever committee of creditors, they know pretty well because it is a transparent, it is not a confidential. So the COC holds a significant power supervising RP's conduct. If at all you are engaging a related party, known person or your friend as a valuer, or if at all you are engaging the services of your relative for the puff transaction, preferential, undervalue, fraudulent and extortionate, definitely CCTV cameras are more. What is the CCTV camera? The employees, the workers, the key managerial person, the corporate data, the operational creditor, the financial creditor, all people, they are always observing your moments. Moments means not walking and other things. Whatever the decisions you are taking, all these things they will observe. Review the performance. The COC should regularly review the RP performance, adherence to the time limits and the complaints. The RPs may not aware because being a banker, I know from the head office or corporate office Bombay, their SARB is the stress research resolution branch. They will send the communication why this case is delayed, what is the purpose of 180 days, why you have they applied, they filed with the NCLT like that. So I should not give any scope for complaint. I have to address the same at the earliest by following the time management planning and following the rules or regulations or code or judicial pronouncement in total, not even 99%. Not even 19. Once request for information, the COC authority has a demand all relevant information clarification from the RP. If a complaint is there, the COC will ask, what is that complaint, boss? Why you are not addressed? Why they have complained to me? Like that. So that scope, that type of this one should not arise. Replacement of RP. If at all you are not listening. Suppose you take, for example, you have appointed one person. That is your relative. Or you are appointed a known person, friend, as a valuer. And the amount, whatever the amount you are going to pay, that is a high side. So number of issues are, if you go through the disciplinary action that is initiated by IBBA on various IPs, definitely you will come across all these things. I will discuss some of the cases before 5 o'clock. Replacement of RP. If RP's performance consistently poor or problematic, the COC can major role vote at least 66% of the vote, resolve and replace the repair. Okay, this man is not fit for the RP. Even judicial pronouncements are also there. In some judicial pronouncement, they penalized also. So that scope we should not. The best practices means it is not imported from other countries. The best is nothing but whatever the guidelines are there, whatever the standards are there, whatever the code is there, whatever the regulations are there, whatever the judicial pronouncements are there, all are to be implemented in toto without even not even 99% also no question. So that's why 66% of the voting share resolved to replace the RP and propose a new one to the adjudicating authority. And approaching if at all COC is also not addressed. Then the hierarchy is there. Na? So if at all RP is not listening, COC is not listening, adjudicating authority not responded, IBBA. So the National Company Law Tribunal is the adjudicating authority, has inherent powers to ensure smooth and timely and fair resolution process. The filing of application. Any aggrieved stakeholders for COC can file an application with NCLT under section 60, subsection 5 of IBC to address the specific grievance. So the aggrieved stakeholder, either COC can file an application with NCLT. Everywhere the provisions are there. If at all you are not given justification or you are doing wrong things or anything, definitely it will be escalated. Today, some of the RPs are also blacklisted by the banks. Blacklisted by the banks. Even my bank also, some of the RPs are also blacklisted. So once that is there, definitely the image risk, na? Even other RPs, they will tell, oh no, this person did like that. That's why they have removed, they have cancelled the certificate of practice, means it is an image risk. So that should not arise. Now coming to, this could be for issuing direction. If at all you are approaching the honorable NCLT, if at all you are facing the problem, issuing direction to RP to perform specific duty and provide the information. But once initial stages only, if you address that issue, they will not go to the top. Na? To two layers, they have crossed. The another layer is IBBI, Insolvency and Bankruptcy Board of India. So setting the removal of IRP or RP for negligence or misconduct. In so many cases, the misconduct, IBBI, if at all you see the misconduct, so many people are there, misconduct, and they stopped and they asked to undergo again 50 hours pre-registration type training. And some people penalty 1 lakh or 2 lakhs or 5 lakhs. Some people they cancelled the certificate of practice. They are not eligible to act as the RP, challenging a decision made by the RP. So this could be for why they have approached means you have not addressed their whatever the complaints are there. So we have to give much attention. That's why 180 days means if at all cases there full-fledged, you should be stay there only one case. One case means you should be 10 to 5 or 10 to 6, you should be in the company one. Then only all these problems are resolved. Otherwise, the quality of CIRP will reduce. Full-time devotion is also one of the important criteria to complete the corporate insolvency resolution process. Once the NCLT orders are given, NCLT can intervene, pass necessary orders, give direction, or even order removal of RP if a sufficient cause in the is shown. What is the continuous education program, CEP program? So, whatever the best practices, whatever the judicial pronouncement, from time to time, once or twice, all the faculty will enlighten you. For that purpose only, IBBA introduced the COP hours. Filing of complaint. Okay. You have not addressed. COC not addressed. And NCLT it is pending. Then there is no other way. But so today, even if you open the website to a complaint, and what is authority, what is their email, what is the phone number, landline, all are available. All are available. Then the person, aggrieved person, definitely he will escalate. He don't want to wait because had it been happened to you also, then you will not tolerate. The Insolvency and Bankruptcy Board of India regulate responsible for oversight and discipline of the IPS. If at all the regulator is not there, the IPS will act as per the wish and fancies. Professional misconduct. If the issue involves a breach of IBC Act, the IP regulations 2016, or the Model Code of Conduct, can file a formal complaint. Formal complaint. And IBBA grievance and redressal mechanism, GRM, or the discipline, definitely they will address. First, initially, they will send the number. Later on, whatever their information required, all the information they will collect, and accordingly, they will resolve the issue. That stage should not arise. That stage should not arise. Investigation. Today, IBBA, the mobile auditors are there, investigators are there. They will come to your office. They will verify the total correspondence, whatever the paper with regard to CIRP. Sometimes they will approach the COC also, members also. Whoever is given the complaint, they will also meet and address the issue. The IBBA investigates these complaints and can impose penalties on the IP, which include suspension or cancellation of their registration. They will cancel. So, in the coming slides, what penalties in which companies and which CIRP, all are included. So, here the complaints should not arise. Okay, in a rare case phenomena, if at all it is inevitable and you are 100% correct, then automatically that type of complaints, if at all they meet so many people also, then no result, no solution for me. But from my part means your part, you should be perfect, man. Perfect. Whatever the best practices I will discuss, whatever the best practices are there, I will discuss now. Okay. Now coming to okay, sir. Because somebody is talking, that's why I'm waiting. So sir, PPT is visible, sir? Sir? Hello?
Yes, sir.
Okay, sir.
Yes, sir.
Now summary of our best practices I will discuss. What are the best practice? To effectively manage the potential issues, be proactive. Stakeholders should actively participate in COC meetings and monitor the CIRP timeline closely. For that, you have to be proactive. So, no complaints, no adverse remarks, no pinpoint about your drawbacks. That scope should not be given. So, be proactive. Not only that one, document everything, sir. Suppose one operational creator claim is rejected and Xerox copy you send, original is with you. On the original also, why you have returned, what is the reason, when you have sent, under which post, speed post or courier, if a courier, what is the number or speed post, and file it. Later on, if at all the person is approached any other the higher authorities, definitely this proof is sufficient for us. Document it, everything. Maintain a record of all communication, date-wise, activity-wise, values, one file, COC meeting, another file, advertisement, expression of interest, another file, resolution profession, the resolution, particularly information memoranda, another file, or the prospective resolution applicant, those who are submitted the resolution plans, another file. If all are there, it is easy to retrieve. Date-wise, that is important. So, that's why the full-fledged IRP is, or RP is required, not part-time people. So the COC CIRP requires full-time devoted, then the professionalism will increase. If at all half-heartedly or I'm spending half an hour or 1 hour, then this document is a crucial evidence for any application to NCLT or complaint to the IBPA later on. So later on, definitely it is useful. That's why for this case, number of books, number of one laptop is sufficient. Standard formats are sufficient. IBC, the 2016 code book is required and regulation. That's all. Here, big, that act, this act is not required. If at all your judicial pronouncement is there, you put it on a index box file, take a printout. Even ICSA, the learning curves, half page of all judicial pronouncements, half page only. Top the ICSA, the insolvency profession, all these things below, the name of the person, signature, all this, that is not required. The body of the particular case is only one page. Even today, the quarterly journal of IBPA gives good knowledge about IBC. Good knowledge about IBC. Seek legal counsel. So, CIRP is also a challenging one. Today, even though IBC prevail over other acts, still some litigations, some the legal issues will arise during the course of CIRP. at that time, you are eligible to engage the service of the legal experts with experience in the IBC matters to navigate the legal complexities of the process and ensure application are filed correctly on time. So on time it is to be addressed. On time it is to be addressed. Otherwise, if at all you are delayed, then that is also create a problem. Take the advice of the legal experts and address the issue instantly. The amount you can pay from the CIRP, that too with regard to the company only, that too with regard to CIRP process only, it is a part of CIRP cost. In a CIRP, the interim or resolution encounter significant hurdles, often push the process beyond mandated 330 time. So, if the significant hurdles are there, overtake the hurdles. Otherwise, it will cross 330 days. Hurdles are there. Even if at all you cross it, for that purpose only, the IBBI is engage the services of the professionals to handle the CIRP cases. So here adults without no hurdle, but small cases where there is no hurdles and only one single financial creditor or only some operational creditor is there. That is not a big case. That is a small case. As of now, if at all you are verifying the average time for resolution plan extended significantly, sometimes it is reaching 760. Where is 330 days? Where is 760 days? If you see the number of cases, date of filing, and put it on this Excel sheet and average it, that is some cases 760 upper limit. Some cases within 2 months or 3 months it will be closed because some of the corporate data they are ready for the compromise. One is non-cooperation. One biggest challenge wise and how to address with the help of regulation and all these things I will discuss. The first challenge is non-cooperation by the promoters and management. This is a challenge because you are the foreign body entering into the company. You are the foreign body entering into the company. Even in human body also, if at all any foreign body is entered, then reaction will come. So in the similar manner, in the company or in CIRP also, you are the foreign body. Once you are entered into that particular this one, definitely some reaction. They don't cooperate. They don't provide. Even the books are there. Even the books are where you are staying in that compound, it is available. But you don't know. But they don't inform. Suspended directors often refuse to hand over crucial documents. They don't give financial records or physical position of assets, leading to complete information memorandum and delays in valuation. How many assets are there? What type of liabilities are there? And where the assets are located? The inventory, where it is, in how many locations it is there. So all these things, non-cooperation is one of the important challenge. But how to overcome? Okay, this is the challenge. I should not leave it like that. I have to overcome that challenge. Section 19, subsection 2, application. RP must immediately file an application before NCLT seeking directions for cooperation. The NCLT is having full power. They can arrest also the corporate debtor. They can give the orders to arrest the corporate debtors. So this should not be delayed. Some of the RPs, they will try. How long they will try? In the meantime, 180 days will complete. They should not wait for trials. This is not a trial platform. So what is the next? So the RP must immediately file an application before the National Company Law Tribunal seeking directions for cooperation. Local authorities also, that support also, RP can request NCLT to direct the local district administration or superintendent of police to assist in taking over the position of the records and assets. Once you are going to take the assets, then lot of resistance. So that's why even as a bankers, we know it is a big challenge. But in Surat, that is in Gujarat state, the joint collector has given good support to the bankers. Thereby, bankers are able to recover number of loans under SARFAESI Act 2002. So thereby, the regulator also appreciated the efforts of the particular collector. Invocation of penalties. If a non-compliance persists, RP can push invocation of section 7, subsection 70, subsection 1, which carries a penal consequence for withholding the information. Even some of the authority, they particularly NCLTs, why you are delayed? Sir, that the corporate debtor is not cooperating, sir. Today, how many days completed? 60. Why you have not informed day 1? If at all non-cooperation is not there from the corporate debtor, why you are delayed? Then the adjudicating authority impose the penalty on the RP for delay in communication. So the invocation of the penalties. If non-compliance persists, the RP can push the invocation under section 70, subsection 1 by IBBA, which carries penal consequences for withholding the information. Litigation and judicial bottlenecks. What is the challenge? A flood of interim applications, IAS, and from disgruntling stakeholders and frivolous complaints against RP often clog the system and drain resources. Because it is a calm period, because a moratorium is there. During the moratorium, Aram say calmly he can do whatever his best is there. But if this type of interim applications, he has to spend some more time for that overcome this litigation judicial bottlenecks. What are the ways and means are overcome? How to overcome? Mediation. You call the people. Why they have filed the application? What is the problem? RP are increasingly encouraged alternative dispute resolution or mediation for intercorporate disputes to avoid lengthy NCLT hearings. If at all still NCLT is there, you have to prepare, you have to visit, you have to address. In the meantime, who will look after the CIRP? Continuous hearing. If at all you have not presented, then it will be a problem. They will postpone. After that, they will give in favor of the person who complained against you. Instead of that, each and every hearing you have to attend. And whenever you are attending with the full information, with the proofs also immediately submit, thereby the time lag or a delay will reduce. Continuous hearings, RP can petition NCLT for continuous hearings and fewer adjournment to adhere the strict timelines. Legal disclaimers. To defend against the frivolous complaints, RP rely on the protection provided under the code for actions in good faith with strictly following the IBBA code. So you need not worry. Once you are a 100% pakka man, a complete man, following the rules, regulations, and code, you need not bother about this frivolous compliance. Don't worry. Financial and operational constraints. What is the challenge? Many corporate data are cash starved. Day one, you are going there. Nobody is there. Security staff and skeleton staff is there. The bank accounts already they have withdrawn. One day they have no balance. Working capital loan, the total drawing power they have and they used. Nothing is there. Who will bear the expenditure? Who will bear the expenditure? If at all you are asking financial creditors, he will tell, no, my discretionary powers are not there. I have to get the permission from the top management. Operational creditor, if at all you ask, operational creditor will tell, no, sir, the fund is, the whatever the stock I have supplied, the funds are blocked. I am in liquidity crisis like that. So here, that's why to overcome that problem initially, the NCLT is also requesting the financial creditor or operational creditor, whoever is there, along with application, they will ask some advance amount also to meet the CIRP cost. Particularly in Hyderabad, the CIR, the adjudicating authority also for application, 3 lakhs like that they will take. That amount they will give it to the RP. That will be created and they have to spend and they have to account for and they have to get the post approval from the after COC is formed. Many corporate data cash starved, making difficulty to maintain a company's going concern or pray for mandatory costs like valuation and forensic audit. Because the company is suffering, the company is in liquidity problem, the company is unable to pay the debts, how they will bear the CIRP cost? Even financial creditor, they told, no, for this, only one alternative available is the unencumbered assets are there, mortgage that one, get the funds. So this is a challenge, but how to overcome? Interim finance. The RP can raise the interim finance with the approval of committee of creditors to meet the essential operational expenses. COC funding. If the corporate debtor has a zero cash flow, the RP must ensure COC financial creditor to provide an assured and fund mechanism or CIRP cost to perform statutory duties. So here, RP can raise interim finance with the approval of the committee of creditor to meet essential expenditure. COC is sometimes funding also. If the CD is zero cash flow, the RP must ensure COC, financial creditor, to provide an assured funding mechanism, CIRP cost, to perform the statute duty. You request, you made a request. If at all it is not there, definitely there is no use at all. There is no use at all. information gap and asset valuation. This is also a challenge. Outdated balance sheets and missing financial records make it difficult to determine the fair value and the liquidation value of the asset. How many assets are there? Latest balance sheet is not available. Last year, it is not available. Before last year, it is available. After that, you have to reconstruct the balance sheet. Outdated balance sheet. If at all it is there, you have to reconstruct and give the valuer to take the stock of the assets and give the valuation report. In the similar manner, the PUF transactions also. The preferential, undervalue, extortionate, and fraudulent transactions. How to overcome this? If balance sheets are not there or partial financial statements are there, how to overcome? Appointing forensic auditors help to identify the avoidance transaction, preferential, undervalued, and fraudulent, even when records are incomplete. So they will provide some information. Anyhow, you are going to engage the services for PUF transaction, and accordingly they will give suggestions or support to frame the balance sheets also. And the information utilities. RP leverage the data from NESL, National E-Governance Services Limited, India's primary information utility, to verify claims and financial defaults independent. So this is also another strategy to overcome the challenges. Managing statutory and external regulators. This is a challenge. Jurisdictional overlap with other regulators. RERA for real estate or CIRP for power sector can lead conflict of legal requirement. RERA, I am the regulator. CIRP for power, I am the regulator. Like that, everybody will tell. But in that case, where the IBC prevail over other acts, but here we have to take their support and the confidence level also. Otherwise, it is very difficult. That's why in the real estate sector now, in the COC, the real estate RERA people, officials are also the one of the sitting member in the COC. We have to invite the RERA because they are the experts. They know about the company. They know about the RERA regulations. They will give the suggestions to overcome the problem of the home buyers. So this is a mandatory, and they don't have any voting rights, but they are invited for the COC meeting if the case is related to real estate. How to overcome this problem? Collaborative framework. RPs establish communication channels with the sectorial regulators to ensure the resolution plan complies with both IBC and the sector-specific law. That is required. RP establish communication channels with the sector regulator to ensure the resolution plan complies with both IBC and the sector-specific laws. Moratorium protection. RP strictly enforce the Section 14 moratorium to stay all legal proceedings against the corporate debtor, providing calm period for resolution. So, whatever the moratorium is there, the moratorium you have to maintain in total. So that's a collaborative framework is also required. Their support is also required because they are the experts. It doesn't mean you should not dilute the moratorium and other things. Moratorium should be continued, but at the same time, you have to get the support from the other regulators also, like power sector or the RERA, Regulatory Authority for Real Estate. Now coming to, suppose you have not followed the best practices. What is the consequences? Consequences are more. You have to face it. The consequences you have to face it. Best practices means not borrowed, not imported from other countries. If at all we are following whatever the guidelines are, whatever the code or whatever the judicial pronouncement from time to time or whatever the regulations that are there, how to overcome that problem, all these things, if you know, that is a super best, not even best also. So if at all we have not followed, the RP has, IPs are facing the problem of disciplinary cases. That should not arise. That should not arise. Under the new insolvency regime, on initiative of CIRP process, the powers of the management board of the corporate debtors suspend and get vested to IRP, appointed by NCLT, the adjudicating authority under IBC, to manage the operations and assets of the corporate debtor. This is the procedure. IRP or RP play a vital role. Everybody knows about this one. Efficient operations of the CIRP and regulates and manages the administer the entire IBC, the insolvency and bankruptcy process as an agent to the adjudicating. You are the court appointed officer. You are the administrator. The decisions to be taken by the COC only. You are the court appointed officer of NCLT or the agent of the adjudicating authority. What are the various penalties that are levied or imposed by the IBBA from time to time, if at all we are not following the guidelines or practices? That's a IBC law and practice. Insolvency and bankruptcy code law and practice. Even we are calling banking law and practice. Sorry, up to this point, any doubts are there, sir? Hello? Am I audible, sir? Hello?
Yes, sir.
Audible, sir.
Okay. As per Vishwanathan report 2015, this creates the positive externality of a better utilization of the judicial time. The worse performance of RP, the more adjudicating authority may need to personal supervision and process. If at all you are good, I need not bother about control you, because you are the appointed, you are the officer appointed by the NCLT to look after the CIR. So here, if at all you are following all the rules, regulations and code and judicial pronouncement and from time to time, NCLT need not worry about this. Otherwise, NCLT has to spend more time on you also, whether you are doing correctly or not. That's why instead of that, they will remove and they will replace with another IP. The worse performance of RP, the more adjudicating authority may need to personally supervise the process, which in turn inordinate delay. If at all you are caliber, if at all you are knowledgeable, If at all you are handling the case perfectly, NCLT need not worry. NCLT need not closely monitor your moments of the CIR. Efficient regulation by RP. In turn, ensures maximization of assets and less adverse impact on the investment and economy of the country at large. The final is, once the CIRP is good, definitely it not only helps to the stakeholders, but economy as a whole. Such authority important function, an RP cannot be left unregulated. Important function of an RP cannot be left unregulated. Endeavor is to look discretion to give the disciplinary committee under the code and how it have been exercised to help us understanding whether the checks have been proportionately laid down and practiced. So being an RP, whatever the checks are there, whether you are properly implemented or not, that is to be overseen by the people and the disciplinary commission. If at all you are not doing correctly, then they will impose the penalty, they will cancel the certificate of practice, etc., etc. As per section 220, subclause 2 to 6, the disciplinary committee, on being satisfied that a sufficient cause exists, may impose a penalty or suspend or cancel the registration of a insolvency profession. So 220, if you go through, in that 220 subclauses 2 to 6 is there. The disciplinary committee, on being satisfied that a sufficient cause exists, may impose the penalty or suspend or cancel the registration of the insolvency profession. The penalty prescribed 3 times the amount of loss caused. They have clearly mentioned whatever the loss incurred, 300%, are likely to have been caused by the persons concerned on account of such contravention, or 3 times the amount of unlawful gain made. If at all you have gained some amount on account of that particular transaction, whatever the gain amount is there, that is also 3 times such a contravention. In cases where the amount is not quantifiable, an upper limit of 1 crore has been fixed, imposition of penalty. So once it is not quantifiable, maximum 1 crore that is to be fixed. Additionally, IBBA may direct any person who has been unlawful gain or averted loss by indulging in any activity, contravention of the code, to give the amount equivalent to such unlawful gain or aversion of loss. So that's why penalties are there. There is no other alternative except to follow the stipulated guidelines, stipulated code, stipulated judicial pronouncement, whatever the judicial pronouncement, whatever their final verdict, and accordingly you have to follow. Accordingly you have to follow. Names of the corporate data. One by one, corporate data, how the RP is not following the best practice, and what punishment the disciplinary committee is awarded. All these things I will discuss one by one, etc. King's Electronic Private Limited, CIRP, dated 11/8/2023. This is one case. In that case, what has happened? Contraventions. What contraventions are made? One, irregularity in voting process. IP has contravened the provision of the code and the regulation, not counting the votes of two major COC members. Why he has not counted? Once you are classified as a financial creditor, once he is voted, what is the problem? That is Union Bank of India and Bajaj Finserv Limited having 18.10% and 14.70% voting respectively for replacement of her as RP. As a result, said agenda could not be passed. That is not correct. If at all I am appointed as an RP, if they are not happy with my skills, knowledge, and handling of the CIRP, you are having every right to remove me. And if that the two finance companies also, they are not happy with the way, they have not counted. So simply the agenda could not be passed. That too 18.10 and 14.70, that is 32.80% voting, he is neglected simply, which is not correct. If a vote of either both of COC member, that is Union Bank of India and Bajaj Finserv has been counted, Mrs. Poonam Vasak, IP, would have been replaced. So on account of this one, he is continuing. The erroneous voting is benefited and served as a personal interest, which can further lead to COC members to approach adjudicating authority for replacement of RP and the extension of a CIRP period. Definitely they will approach. Sir, we have given and we have asked to remove that particular person and our voting rate is 14 point so, 18 point so, that was not materialized. Correct, remove. Seeking appointment as a liquidator. Bypassing COC IP on completion of 270 days. Without consulting COC file the liquidation application wherein she prayed adjudicating authority for confirming her appointment as a liquidator despite knowing that the application filed by COC for extension of CIRP was pending. Seeking appointment as a liquidator by bypassing COC. COC consent is required. As a liquidator, IP and completion of on completion of 270. Okay, once 270 is there, either liquidation to be recommended or the particularly extension. That is the right with the COC. But what was happened? The confirming her appointment as a liquidator, despite knowing that application filed by COC for extension of CIRP was pending. Once a CIRP to be extended, that is the request of the, that is the desire of the COC. But 270 completed, please continue me as a liquidator, like that she applied. Consequently, adjudicating authority allowed the application of the COC and replaced Mrs. Poonam Vasak as a RP and appointed new RP. The CIRP period has been extended by adjudicating authority. So why some people they know about the rules, they know about the regulation, then they should not do like that. Adjudicating and rejected the application filed by IP for liquidation. He is not authority. IP is only the facilitator. IP is only the administrator. IP is only the CEO with the voting rights, and all these things are vested with the COC. IP is only court appointed officer. IP is agent of the NCLT. not beyond. You are not a judiciary authority. Penalties and directions. So once these people are doing, definitely the disciplinary committee of IBBA, they will impose a penalty. What penalty in this case they have imposed? Suspension of registration as an IP for a period of 3 years, which is not correct. The specific regulations are there, the code is there. Everybody knows about that liquidation to be recommended by the COC, that is to be approved by the adjudicating authority. Next, everybody knows about RP is a facilitator or administrator or court appointed officer or agent for NCLT. They should not take into the power of a law in their hands. So thereby the punishment is suspension of a registration as an IP for a period of 3 years. What is the learning lessons we have done through this? The learning lessons are inordinate delay, 270. It should be completed within 180 days. Destroy the value of the asset. Once it is delayed, the value of the asset will decrease and make the performing asset non-performing. Good assets are there. If at all delayed, the machinery will not be useful for resale also. Failure to act as the objective is mandated to the court, that is a resolution, and COC as a decision-making body. COC is a decision-making body. You are not the decision-making body. You are only the facilitator. You are providing the particular information to the COC. COC will take a call, not by you. But you are working the directions of the COC, the directions of NCLT. Name of the corporate data in another company. What was happened if they are not followed the best practices or the existing practices? In my opinion, best practices is nothing but whatever the existing rules, regulations, and code and judicial pronouncement decisions. That is if you implement, that is more than a best practice. IV or CIRP, it is under liquidation. 2nd August 2023. In that case, what was happened? Contraventions. Prescribe non-refundable participation fees. IP in the first e-auction process called a non-refundable of 25 lakhs for the bidders to participate in the bidding process. There is no such guidelines. Why he has prescribed 25 lakhs? Because a hidden agenda is there. If at all prescribed, some people may not participate in that particular e-bid. Later on, what was however, he removed the condition for the pre-bid participation fees by pushing an addendum to main advertisement. No, that earlier we have mentioned erroneously, you need not pay, come. A non-refundable process participation fees was again prescribed for participation in the second auction, where 23 prospective bidders only 3 deposited the fees, which indicates that the submission of the said amount acted as a deterrent for the prospective bidders. Out of 23 people, only 3 people they have paid that amount. Remaining people they have not paid. But his intention is once I have put that amount, most of the people will be filtered. That to 25 lakhs. To conduct the IP in the auction of assets, the CD is inconsistent, unfair, and not accepted. Auctioning the assets of the CD is inconsistent, unfair, not acceptable. Delayed valuation during the liquidation process. Delayed valuation during the liquidation process. It is delayed. On account of this one, delayed. IP has appointed valuers for valuation. One more. After more than 2 years. Why more than 2 years? Why more than 2 years? Once you have appointed a liquidation commencement date, if the CIRP is over and taken lot of time, fresh valuation is required of the liquidation commencement date for determining the reserve price for a third e-auction process on the advice of stakeholders consultative committee. So once they told, then only started the valuation third time. The reserve price in third auction was reduced by 25%. First auction, no bidders. Second auction, no bidders. Third one, 25% he reduced. So he want to give some favoritism to the buyers. Hidden agenda. It had been reduced by 10%, where it had to be reduced by 10% only, which has significant financial implication. Where is the 10%? Where is the 25%? 15% extra? Once that is there, the value of the particular profits will reduce to distribute to the stakeholders. So this type of things are doing. That's why every time the best practices means what are the existing practices? If the IRP or RP implemented, then the problem will not arise. It is a duty of the IP to guide the stakeholders, the consultative committee, pertaining to such actions. Fees of the BDO, restructuring advisory of LLP. Fees of the BDO, particularly they have imposed the fee that is paid by advisory LLP, who is given the advisory services. For that also he paid amount. Fees of IP, insolvency professional entity, for initial 8 months was 55 lakhs, which was subsequently reduced to 27.5 lakh per month from 9th, and it was further reduced to 15 lakhs per month onwards. What is the need of taking the IP services? For what purpose? Okay, you require the services. Okay. First 8 months, why you have charged high? After subsequent, why you have reduced to 21.5, 27.5? Later on, why you have reduced further 15 lakhs per month? So there is no document on record detail. The objective criteria appointed and adopted in the fixation of fees of IPA and also fixed amount is not reasonable. Today, number of cases. So that's why we should not dilute whatever the guidelines are there, whatever the regulations are there, whatever the code is there. That is called the best practices. Implementation of the actuals, implementation of the existing guidelines is much more than the best practices. So on account of this one, definitely the disciplinary authority impose the penalty. What is the penalty imposed? Suspension of a registration of IP for a period of 1 year. Is it not an image risk of the IP? Is it not an image risk of the IP? And after a restoration of 1 year, who will give the cases? If at all they have opened the IBB website also, this remark is clearly visible. Learning lessons. What are the learning lessons in this regard? inconsistency in conducting the auctions during the liquidation period. Why inconsistency? Why not continue? First auction is not, the bidders are not there. The second option, the price is not up to the mark. Immediately, why gap and a delay in valuation? And why you have given a 25% reduction? If bidders are not there in the next auction, only 10% reduce. That's all. Lack of objectivity, lack of transparency, the justification, reasonableness in fixation of the IPA and support service. Today, some of the people, they are taking the services of IPA. For what purpose? For what purpose they are taking? So, the clearly mentioned, for what purpose you are taking the services of IPA. If at all is justifiable and the fees is reasonable, nobody will object. But in the earlier, in this case, initially high, after that reduced low, after further reduced low also. Name of the corporate data. The another case. What is that name of the JSM Devicons Private Limited? This is CIRP 27/7/2023. What is the issue in this? Why they have diluted the best practices or laid down practices? Instead of best practices, we can mention laid down practices. What is the contraventions? What are the contraventions? Charging fees for verification of claims. Is there any regulation in this regard? Charging of fees for verification of claims. Is there any such regulations? A sum of 1,24,500 for verification of claims at the rate of 500 per claim for 249 claims were charged. Further, a sum of 1,87,000 for verification of claims rate of 500 for 374 claims were charged and made a part of CIRP cost. Who told that there is a charge for verification of claims? One side, the company is facing problem, the liquidity problem. And if they are charging like this, and the sickness of the company will further sick, and it is very difficult to rehabilitate it. It is very difficult for the prospective resolution applicant also to handle this company. Delay in filing the report of certifying the constitution of a COC. Once the claims are received and segregated financial creditor and operational creditor, what is the problem in constitution of the COC? There was a delay in 10 days in filing the report certifying the constitution of COC before adjudicating authority. However, the submissions were made justifiable as the delays is not intentional because IP was wanted to get the document and the clarification for a maximum number of home buyers so that they may be included. Okay, this is not intentional. Okay. Delay in conducting first COC meeting. There was a delay of 8 days in conducting the first COC. Okay, constitution is one area. Second one is the delay in COC meeting. What penalty they have imposed? The disciplinary committee of IBBI directed IP to deposit an amount of 1,87,000 in the account of CD, JSM Devicons Private Limited. If the same is already paid to the IP from the accounts of a CD within 45 days issuance of the said order. Is it not a image risk of the IP? This is not your account. As per your wish, you have to withdraw. This is a company's account. Whatever the regulations are there, you have to follow, and accordingly you withdraw the amount. Nobody will object, nobody will complain. If at all complaint, that complaint will also not stand. It will stand. Learning lessons. What are the learning lessons? IP was wrongly presented to the COC. An additional expense for verification of claim, which is the inherent duty of the as an IRP. So once IRP is not done, you have completed means you have to charge. So that is a duty of IRP. That's why he is not done. I have done. That's why 500 rupees per claim. Where is the regulations? Where is the circular of IBB in this regard? Names of the corporate data. Another case. Hirakud Industrial Workers Limited. Dated 13 July 2023. What is the issue? Contraventions. What are the contravention? Constitution of COC without verification of claims. Financial creditors were admitted into the COC based on the confirmation of debt letter of the CD and not based on the verification of books of accounts of. Once the claims are received, whether the claims are reflected in the corporate data of books or not, we have to verify. Then only the claims are to be admitted. Why there is a lacuna? Why there is a dilution? If IP has failed to verify the claims of the creditor with corroborating documents, whatever the documents are there, failed to verify whether he is a genuine financial creditor or not. If at all operational creditor, suppose I have filed some public announcement came, I also filed, the company is due 5 lakhs and I have created, fabricated one invoice and filed. Are you admitting that invoice? Why Mr. Prasad is filed, whether it is there in the books of records of the company or not, then you please admit. If at all it is a genuine and a cross-check up to last rupee. Non-compliance of adjudicating authority, submission of proof of claim. COC member, adjudicating authority passed the order on 28th to 2020, directing IP to produce the sufficient proof of debt, but this order was not compliant. Once the NCLT given an order, that order you are not responding. Is it a best practice? Is it not a violation of the ground rules of the code of conduct? The adjudicating authority against the wide order 12/11/2020 noted that previous order has not been compiled and gave a lost chance to compile. Why the unnecessary stinkers from the NCLT by the IPs? Some of the IPs they are doing like this, which is not correct, which is not acceptable. However, it has been observed that Honorable NCLAT order dated that IP filed an IA 341 of 2020 for modification of the order dated 12/11/2020 rather than complying with the same. Hence, IP did not comply the order of adjudicating authority dated till 12/11, 9 months. That is 9 months thereafter, made an attempt to modify the order dated to 12/11/20 that required him to submit the proof of debt of a financial creditor included in COC and did not readily submit the required details to the adjudicating authority. Why you have delayed first? After delayed, you have admitted the creditor in the particular COC. And A2, you have to verify the submit the proof of debts. You have to verify proof of debt. You have to submit. All these things are not up to the mark. The quality in this particular IP is missing, and thereby the IP is not fit for this profession. And accordingly, the adjudicating authority, they will take the action. Inclusion of related party of a CD into COC. Unrelated financial creditors. The meaning, the definition is also like that. Why have they included related financial creditor? There was a connection between the CD and Nandakini, the applicant of a FC, member of COC, and a successful resolution applicant through a network of common directors, different levels shareholding, which dissipates the various members of the COC related parties of the CD have been unduly assigned voting right. The basics of the IBC. Some of the RPs, they forgotten to follow the basics of IBC. COC is an unrelated financial creditor. So once the related parties are there, they are not eligible to sit as a COC member. The successful resolution application is also ineligible as per the section 29A of the code to submit the resolution plan being a related party of a CD by having common director. So if that is the case, the NCLT will take a severe action. So today, what is happening is, with some people, some IPs, they are doing in a casual manner, not in a serious manner. That's why initially I told the casual approach should not be there. It is a serious profession. And one side the court is there, second side the regulator is there, third side the COC is there, fourth side all stakeholders are there. Fifth side the insolvency professional agency is also there. And beyond all these things, the public also there. Signing affidavit under section 29 on behalf of the resolution applicant, IP has affixed his signature on the affidavit 13.2, read with section 29A, which was required to submit an authorized representative of a successful resolution applicant. Despite a successful resolution applicant being a related party and ineligible under section 29A of the code, IP submitted the compliance certificate in favor of the finding them eligible submission of the result. Do the IP think that NCLT is closed their eyes, or IBPA will close their eyes, or other people will close their eyes? So it is not a best practice. It is not at all a practice. Leave it of the best practice. Once a dilution takes place, once the bypass of the regulations, it is the disciplinary action eligibility. Failure to obtain the claim form of the workers, CDIP aware of the substantial claims of the worker, ongoing proceedings before the High Court. Failed to consider the same. And I also did not advise the workers to file the claim with him. Once, even though the amount is with the High Court and other things, once they have submitted the claim, he has to honor the claim. especially statutory claims including PF, Provident Fund, gratuity for the workers of the city not sought, no provision was made for the same in the resolution plan. In that case, that resolution plan, no commercial wisdom, nothing, the shield is already broken. So this type of the some of the people they are doing wrong things. They the professional code of conduct strictly they are following, and from time to time the adjudicating authority warning those people who are bypassing. Not only that one, the disciplinary committee of the IBBA they are taking suitable action against those IPs. The conduct of IP appeared in a modified and subsequently lead to crashing the resolution plan by the Honorable NCLT as the interest of all stakeholders was not taken into consideration. In that case, they don't, even though NCLT by mistake error, they have accepted, that will not be finalized. And the penalty, registration of IP stands cancelled permanently. So this is a great image risk. If at all he is other professional also, it impacts on other professional this one also. So learning lessons, IP has facilitated erstwhile management, directors of the CD, in extinguishment of all past liabilities and also prosecution for criminal offences, thus conducting the resolution process of the CD in gross violation of fiduciary duties entrusted him under the code. IP has shown casual and a lack addition approach with regard to workmen dues. So this type of things should not happen. Okay. Now, shall we take a break for tea, sir? For 10 minutes? Hello?
Yes, sir. Sure, sir.
Okay. Okay, sir.
मैच का बताते ना, फाइल कर दिए।
Okay, sir. Shall I start now? Okay. Uniworld Sugars Private Limited. This is CIRP. The date is 6/7/2023. In this case also, whatever the procedures are not followed, then what penalty they have imposed, that also we will go to contraventions. Failure to conduct a required due diligence of the resolution plan. Whatever the resolution plans that are received by the RP, that is to be properly verified. There was a third valuation conducted in the behest of OCOC member. However, third valuation does not seem to be affected the distribution of the resolution plan. So once you have given the particular the valuation, that is not affected the distribution of a resolution plan. If at all the third valuation is more, then the resolution plan will also be higher when compared to the earlier one. COC, in the name of commercial wisdom, exceed its mandate. However, supporting logic that have been during pandemic, the value of the assets in general registered a drastic fall. And the COC in many cases in jail to get the latest valuation of the CD insisted for a third valuation to be done during extraordinary time of a pandemic of COVID-19. At that time, across the world, they have suffered a lot. And people are also not happy, and they are not they willing to acquire the assets, and the asset values are also decreased, and the no sales, no the economic progression, all these things are there. That's why the value naturally, if nobody is ready to purchase the properties, value will be less. It doesn't mean that is the real value. After pandemic, again, the values of the properties are zoomed like anything. As mentioned in Honorable NCLT, such a precaution exercise violative of Regulation 27 and 35 of the CIRP regulation. However, the role of RP in pursuing the third valuation is not established beyond doubt. And penalty. What if penalty they have given? The show cause notice was disposed of. So here the learning lessons are IP should be more careful in presenting the matter before adjudicating authority and honorable NCLAT. Name of the corporate is Jogama Laminates, the Industry Private Limited, CIRP. That is 3/7/2023. What is the case? Contravention, non-cooperation of to the IA in conducting the investigation. The investigation authority, suppose take for example, internal audit are there, particularly IBBA or IBA. From time to time, they will conduct, they will come and they will do the audit of whatever the cases you have handled. Non-cooperation to IA to conduct the investigation. IP did not cooperate with IA in submission of a specific response, observation of the adjudicating authority and the relevant records for investigation, thereby frustrating the entire process. Excessive fees claim as RP, adjudicating in its order dated, made adverse comments against IP, charging the same fees for a COVID period as he was charging during normal period. So once we are telling in CIRP, if the employees or workers are not no work, no pay is there. That is the judgment of the Honorable NCLT at Calcutta in AB shipyard. So in that case, why the IP is drawn? If there is no development during the pandemic, for that also he had charged a higher amount. Inconsistency in action and handing over the custody to ex-management. IP orally opposed to the liquidation application filed by himself, and he also handed over the custody of the CD to the ex-management. What authority is having? He is a facilitator, he is an administrator, he is a court-appointed officer, and he is the agent of the NCLT. However, there is no proof on record of substantiate the allegation. Non-submission of a relationship and cost disclosure forms. Why he is hesitated to not submitted the forms? The IP filed the disclosure belatedly and accepted delay in submission relationship cost disclosure forms. Non-submission of a CA form with the board, the IP failed to file the CIRP, the 5 and 6 and 8 form on the website of the particular IIPI, that is IPA of ICI. What penalties? Suspension of registration for a period of 1 year. So the suspension for a period of 1 year. So all these things, the mistakes are not a small mistakes. Learning lesson. Any communication from the IBBA cannot be taken lightly. You have to address that issue instantly. Otherwise, the problem will arise. So here, one judicial pronouncement, the negligence of the IP and thereby how much a problem arises by the home buyers, particularly in claims verification. The error is also there on the NCLT side also. This is with regard to the home buyers case. I told about the home buyers Akruti. So what is the claims? Why the claims are to be properly verified? Once you go through this one, the key learning issues are there. Akruti. In a significant development of NCLAT delivered a landmark order December 9th, 2023 in favor of Aqua City Consumer and Social Welfare Society and the Madhya Pradesh Real Estate Regulatory Authority. This victory represents a rare hope for the home buyers who have been entangled in a legal battle against the builders across India, fighting their hard-earned savings. Because here, the RPs also, once the claims are there, verify thoroughly, simply not accepted. Okay, if at all the initial application, operational credit are filed and the NCLT by mistake allowed, the basic responsibility of RP also, once again, what is the application, what claim they have made, whether it is tallied with the books of records or not, then if at all any mistakes are there, brought to the notice of NCLT also. Sometimes on account of the busy and other things, the NCLT also, they did some mistakes, errors. In this case, the NCLT first they did the error. Later on, the IP, particularly IRP, they have not verified whatever the claims is there. This is the brochures. Every real estate person, they will give rosy pictures, greenery, cars, all photographs they will do. But today's the situation is like this. Today the situation is like this. So the home buyers, they have facing lot of problem. Key learnings. Read the complete application form submitted by the financial creditor. What the financial creditor or operational creditor or corporate debtor by the resolution profession after allotting the case by the NCLT or getting the order from NCLT. You have to read why they have filed, what are the basic documents that they have submitted. Anyhow, you are going to handle that one. Read NCLT order completely before starting the process of CIR. That is also one best practice. Verify the claims thoroughly before admitting the claims. Fraudulent claims, further investigation is required. Appoint the transactional auditor. Even though we are calling as a forensic auditor, forensic audit concept or word is not there in IBC, only transactional auditor. But in normal way, we are talking forensic. We have good knowledge in forensic audit. and particularly the puff transaction of the. Whenever you are selecting any for the transactional auditor, you should have the forensic audit experience for puff transactions. Various agreements reached between the corporate auditor which are pending at the time of CIP has to be studied RP thoroughly. So simply, what are the agreements? Why the debt arise? Whether debt is in order or not. Legal suits filed against the corporate auditor and the decree copies of the judgment of various courts are studied thoroughly. You have to read thoroughly. Then only the case we can handle properly. Follow the code of conduct regulation of by RP issued by IBBA from time to time. What is the code of conduct? And whatever the IP code of conduct are there, go through that one. Follow the Limitation Act of various security documents executed by the corporate data during the course of a business who are pending at the time of CIRP. Today, in NCLT also, whatever the documents are there, the documents are time-bound documents they are filing. So that's why that is also to be verified. And whether it is a time-bound, if a time-bound documents don't allow that claim. And that's why this case, Real Estate Regulatory Authority versus DB Corporation Limited and others, Dayak Bhaskar Corporation Limited and others, NCLAT New Delhi bench, December 2023. On 2029th, the 9th December 2023, NCLT delivered a landmark order in favor of Aqua City Consumer Social Welfare Society, which represents a group of home buyers and Madhya Pradesh Real Estate Authority, RERA, MP, RERA. The home buyers will hopefully get the refund of their investment, interest with Akriti Group, even if they had given up the homes they have invested in. So, first they have filed the case, home buyers, with the consumer form, and they are hope of getting the refund of the full amount. And this is a long, harrowing battle, almost 13 years, may not have ended it because still option for the powerful corporate involved approach of the Supreme Court to delay the justice. Once the consumer form is there, they approached the Supreme Court also. But the important lesson, thousands of home buyers involved in the similar murky battles against the builders across India over a significant chunk of their life savings. A positive aspect of their long road to victory was that the MP era first time fought alongside of the home buyers. Normally, RERA will not fight, but in this case, RERA also involved and fight the alongside with the home buyers, and added weight to the stand that bankruptcy law was wrongly invoked. Wrongly invoked. The bankruptcy law, whatever the NCLT admitted the case, it is wrong. They proved also. They proved also. So this is a negligence of some the areas. Members of Aqua City Consumer Farm purchased a residential apartment way back in 2011-2007 from AG8 Ventures, which is a part of a large business group with interest on reality and hospitality, sugar and healthcare. This AG8 Venture is the Akriti Group 8 Venture. They are experts in reality, hospitality and sugar and healthcare also. Its reality projects are spread across the country, and the brand name is Akriti. Akriti. It is a large presence in Madhya Pradesh with 11 projects registered with the MP RERA. Okay. When the builder was unable to deliver the apartments, the Home Buyers Association moved to the National Consumer Dispute Resolution Commission, NCDRC, and obtained favorable order 2021, that is after 11 years. They established that Akriti has diverted money meant for the project. Okay. The Apex Consumer Firm ordered the builder, the AG venture, that is Akriti Group 8th venture, to refund the money from the date of possession with 9% interest. Once they have paid from the date of construction, only date of possession they have given. But again, it is a problem to the builder. Refund that amount. It is again a problem to the builders. Are the home buyers? I have paid, I have taken loan from the bank long back, and now during this month only the position is not happened. Today onwards they are giving interest. Why not 5 years back I have deposited that amount with the builder, and immediately they approach. However, the order was a flawed. Consumer firm order was a flawed. After all, money ought to have been refunded with interest from the investment date. That is initial application onwards. They are paying phase wise. So he approached Supreme Court of India for modification of the order and obtain verdict in favor of. So Supreme Court, they have listened. Okay, this is correct. Not from the date of the possession of the flat, from the date of that order, the original when they have paid that amount in a phased manner. In August 2021, MP RERA also passed an order against the builder after establishment of the failed to maintain the money collected from the home buyers in a separate designated account as required by the RERA. So he is also not deposited. That also they have filed, diverted the money to other projects. MP RERA ordered a detailed investigation into the finance of the particular builder appointed, and Milan Vaikar as a financial advisor, who was kept a regulator informed and findings and development. So the MP RERA, they sent one investigator, financial advisor, to study what is happened in that particular the builder, all these things. Subsequently, based on the findings of the particular financial advisor, the registration of Akriti Aqua City and Akriti Business Arcade was cancelled by the RERA in 2022, and the agency was appointed to complete the project. So they have cancelled the license to the Akriti, and they have appointed one more person to take up the project and complete the project and hand over the project to the home buyers. The builders meanwhile used every legal form, so they don't keep quiet. And to challenge the orders, enter into collusive deal. Okay, anyhow, RERA cancelled my this one. And what are the various alternatives are available? Then somebody suggested that IBC is there. If at all any operational creditor file an application under IBC, definitely all these consumer forms, all these RERA, all orders are cancelled and nullified. So immediately they have builder meanwhile used every legal form to challenge the orders entered into collusive deal with the DB Corporation, Dainik Bhaskar Group, one of the largest newspaper in MP, a listed company, and to a deadlock action. So this actually the RERA not to be not to be entered into that particular this one, and the revised one more the project they have given, that is also to be stopped. All these things they keep it in mind, and they requested Dainik Bhaskar to file an application with NCLT as an operational creditor against this Akriti builder, because Akriti builder and Dainik Bhaskar, they colluded with each other. To stop the deadlock action, particularly RERA should not take any action or consumer farm or whatever the judgment given, all these things are to be stopped. I need not pay any amount to those people, etc., etc. In January 2022, Dainik Bhaskar Corporation invoked the proceedings under Section 9. So first initially 8 the demand notice, followed by 9 bankruptcy law, claiming that operational creditor and had paid 10.77 crores including interest under barter agreement with the builder. So he told that Akriti is he has to give amount, he has to be paid an amount of 10.77 crores, including interest under barter system, because the Dainik Bhaskar is an advertisement company, the newspaper agency, and they have given a lot of advertisement for this Akriti, and for that the particular Akriti has to pay 10.77 crores under barter system. What is a barter system? So if at all one advertisement given, for that advertisement the Akriti group will pay only nominal amount of the 10 lakhs or so, and one apartment flat they will allot, like that some agreement is there. It transfers that AG 8 Ventures had entered into the barter agreement with Dainik Bhaskar nearly 10 years between 2010 to 2000, a massive advertisement deals. Such deals are allow reality companies to buy expensive and prominent advertisement space in leading newspaper. It has been comfort for the past 15 years. So the Dainik Bhaskar is a media, news media for this the AG Ventures, and they are giving advertisement, and particularly AG 8 Ventures also they are giving some cash, and they are allotting some flats in the particular this one. Under such agreement, the reality companies, a small cash payment for such advertisement, and allot small cash payment for the advertisement and allotting housing units to the media houses for the rest of it. So here the such a మళ్ళీ కాల్ చేస్తాను అశ్విన్. So under such agreement, the reality companies they will pay small cash payment for advertisement and allot housing units to the media houses for rest of it. This is the barter system. Under the 9 agreements, Dainik Bhaskar Akriti has already handed over 22 residential units to DB Group, and the battle 19 more to be remained undelivered. So whatever the advertisements that are given, that all advertisements for that the Akriti has to pay for 19 more advertisements and the amount also. For that he created one invoice and filed an application with NCLT. This is because the Dainik Bhaskar and Akriti, they are colluded each other. Actually here there is no dues by the Akriti to the Dainik Bhaskar, because to stop that the consumer farm verdict or the other promoter they are taking over the particular real estate, these Akriti and the Dainik Bhaskar colluded, and Dainik Bhaskar as an operational creditor he filed the application with NCLT. For readers who think full-fledged advertisement campaigns suggested, they will, particularly Dainik Bhaskar, they will give full-page advertisement campaigns for the Akriti to strengthen the builder. Just one particular advertisement, 25.50 lakhs. Akriti builder paid only 2 lakhs in cash. Rest will be paid by allotting residential unit. This is the barter system. So 25.5 lakhs, 2 lakhs they will pay, and 23.50 that is in the particularly barter system. Barter system. Okay. Now coming to the There was 9 such agreements, adding 14.3 crore and a cash component at 2.64 crores. Cash paid. They are creating that agreement and they are creating invoice and all these things. Actually, this was not happened. This was not happened. It is important to notice the bankruptcy law invoked leads to moratorium on all claims. Hence, orders of the consumer courts and even a RERA cannot be executed against the builder. Against the builder. MP RERA argued before NCLT that a DP was not an operational creditor and could not invoke the insolvency law, as it had done it in collusion with the builder. So, actually, MP RERA also involved in this case because he is doing wrong things, particularly the Akruti. And MP RERA argued that NCLAT, they approached NCLAT that this case was admitted by NCLT and MP RERA approached NCLAT. The case should not be admitted. The Dainik Bhaskar group was not a real operational creditor. They have created the agreements, they have created the invoices and could not be invoked the insolvency as it done collusion with the builder. As an aside, the IBC still settled to respective rights, actions and consumer forms and sectorial regulators such as RERA and the Securities Exchange Board of it. So they are cheating all the people by submitting this one. And a variety of conflict judgments have been invoked by creditors to back their case. This type of practice, some people they are adopting. And during the bankruptcy proceedings, Akruti said that already paid cash component under the barter deal. As the Dainik Bhaskar Corporation demand, the builder is said to be only pay an amount of 5.25, but not interest. Interest is not paid. So that's why but not interest. Principal only, he has paid 5.25, remaining amount not to be paid. During the hearings, NCLT noted that on the basis of a Dainik Bhaskar Corporation, already been converted rights into allotted 19 apartment into a very specific sum money was not clear. Why this 19 cases, apartments? Immediately they investigated into detail. So as the battle progressed, further suspicious details were revealed. MP RERA told NCLT that Dainik Bhaskar Corporation claim itself is a collusion, twisting out of the obligation arising out the reality of the regulator various orders. And it was argued that a barter agreement to pay for lavish advertisement were themselves disapproved by the reality regulators. And a debacle was whether the media house could be position itself as an operational creditor with a claim superior to that of home buyers. So that type of questions also, the RERA is also lot of favor was done to the operational creditor. They are also involved. The advertisement are false. The amount is not due by the real estate that a particular person, Akruti. They have created agreement. They have created the invoices. All these things, all are fictitious transaction. Mr. Akruti was able to obtain certificate copies of documents submitted before NCLT. Now, Akruti buyers, they have submitted the invoices that are due to the Dainik Bhaskar. And the invoice submitted by the Dainik Bhaskar to the Akruti. Akruti also submitted the same in support of the claims forged and fabricated for the case. Whatever the invoices raised by this one, forged, and the same is also accepted by, the invoice are accepted by the particular Akruti is also false. The NCLT order, although the goods and service tax came into force in which year? 2017. Invoices are 2010 2010 had columns of GST printed on them. GST came into the picture in the 2017. But whatever the invoices submitted by the Dainik Bhaskar on Akruti, 2010 invoice also, the GST column is there. Because they forgotten to remove that column. And by mistake, they have mentioned this one and printed on them. It is said that the Dainik Bhaskar Corporation Action invoking section 9 of the law was clear, abuse the process of the law and elaborate why this is so. First, most of DB Corporation claims were time barred also. 210 invoice filed by them outside the 3 years window. So, whatever the invoices filed by them with the NCLT, all are time barred. Time barred means not to be admitted. The NCLT admitted. The NCLT also in 2010 also, why that invoice, the GST column is there. And the NCLT also not properly verified and simply admitted that case. Pertinently, the DB Corporation has already represented itself. LRT of the apartment and the barter has now positioning itself as an operational creditor. And although the creation of confusion shameless, the adjudicating authority was happy to allow without close scrutiny. As the NCLT order that adjudicating authority failed to notice these facts. So even the NCLT also not properly verified, but simply happily they admitted the case. And Messrs. DB Corporation unsuccessfully attempted to appear in the court to file the auction MP RERA as well as the home buyers form. The NCLT order 9th December upheld their stand, says we thus satisfied the entire initiation of the proceeding under section 9 of the operational creditor contrary to the scheme of IBC, and no payment of money was due to Messrs. DB Corporation, and the adjudicating authority committed error in admitting the company to insolvency proceedings. This broad narration has little room to explain money dishonest dealing that was exposed and settled under preceding the multiple forms. The poor people, particularly the home buyers, and the RERA also supported a lot. That's why this is wrong. They have created fabrication because IBC prevail over other acts. Once the case is admitted, the RERA or consumer firm, all judgments are not to be followed. So the Akruti group, they want to continue they want to hand over that particular company within their hands, not to hand over to any other people. For instance, NCLT order mild criticism about the adjudicating authority and makes no mention of the shady actions of the resolution professional against a penalty imposed by Delhi High Court, contempt of proceedings continue. Even whenever the resolution professional verified the claims, he has to once or twice verify the claims thoroughly, whether it is these transactions are available in books of accounts or not. If not, he has to disallow that one. The RERA also imposed a penalty of 3 crores to RP resolution and another 3 crores on AG venture for various violations. So the RERA also imposed a penalty of 3 crores on the resolution profession. And both parties contested the penalties before MP High Court. So the battle continues, but there is a shine of victory for home buyer in sight. So here, whenever you are getting the order to initiate CIRP, first you have to go through the order, read that order, and get the application filed by the either financial creditor or operational creditor, whoever is there, and what are the enclosures, all these things you please verify. And whatever the claims that are admitted by the NCLT, you also verify the same with the books of accounts. Because NCLT, they don't verify. Because based on the documents only, they will admit the case if they satisfy. As a resolution profession, once the NCLT admitted what is that loan or whatever the documents are there, whether it is a time-bound documents or genuine document, whether loan is dispersed, and in the books of accounts also whether the same amount is there or not. Hence, read completely the application form submitted by the financial creditor or operational creditor or the corporate data by the resolution professional after allotting the case by NCLT or getting order from the NCLT. Read the NCLT order completely before starting the process of CIR. Verify the claims thoroughly before admitting the claims. Fraudulent claims, further investigation is required. Appoint the transaction auditor who have good knowledge in forensic audit and particularly for puff transactions of the corporate data. Not simply, if some people, they are simply appointing those who are having a BCom or some audit work. Actually, there is no qualification stipulated in the IBC for a transaction audit. That's why there are some other people that are taking that leverage. Various agreements reached by the corporate data, which are pending at the time of CIRP, has to study by RP thoroughly. Legal suits filed against the corporate data and decree copies of the judgments of the various courts are studied thoroughly. So that also gives us some comfort to you to address the CIRP in a better manner. Follow the code of conduct of the regulation by the RP and issued by the IBBA from time to time. Follow the Limitation Act. Here, all invoices are time barred except one or two. And in that case, the NCLT should not admit. But if at all, along with order, if you get the application filed by the operational creditor or financial creditor or corporate data, then definitely they will enclose the documents also. The documents are live or stale, that also please verify whether these documents are matching with the transaction with the company books or not. That is also to be cross-checked. And security document executed by the corporate data during the course of business and are pending with the CIR. Hence, if at all you have not followed the best practices, this type of problems will come. Even there are also, they imposed a penalty of 3 crores on resolution profession. 3 crores is not a simple amount. So hence they follow the best practices. What are the best practices? Best practices during CIRP under IBC, focusing on ensuring time-bound resolution and transparency, value maximization for all the stakeholders. For insolvency profession, the best practices are prompt public announcement. The interim resolution professional must issue the public announcement in a prescribed manner with 3 days, within the 3 days, appointed to notify all the greater stakeholders about the CIRP commencement and invite come. And one is for particularly the corporate data's website, and the second one is IBBI, whatever the site they have identified. In that also you have to upload the advertisement. Thorough verification of claims. Claims management is very important. That is the next best practice. IP should diligently verify, receive, and collate all the creditors' claims based on the documentary evidence and maintain up-to-date list of the creditor. Whatever the registers and books are available, you cross-check, and if at all it is in profit and loss account or particularly schedules to the profit and schedules to the balance sheet, verify that one, and effective management. So beyond all these things, the another best practice to be followed by IPC is going concern. So as far as possible, the company should be live. Once it is live, then the price will be quoted more. Once it is not live, whatever the amount quoted by the prospective resolution applicant, it is not up to the mark. The RP takes control of the corporate data management and should strive to run the business as a going concern to preserve its value during the process. This involves identify key employees, suppliers, maintaining necessary operations. So you please continue the company as best as possible, and don't stop the wheel of the company. The plant and machinery is to be run. Otherwise, the value will be deteriorated. Once the asset is not used, if at all dust and rust attracted, then the value will decrease. Adhere the timelines. That is another best practice during CIRP. So whatever the best there is there, complete that one before time. Need not wait up to last date. Before all, if you complete, then it will not only complete the particular CIRP, but also value maximization will increase. If at all delay is there, the value of the property will deteriorate except the land value. Not only that one, some of the assets rusting and no use at all. No use at all. And strictly follow the strict timelines, stage of the CIRP. First COC meeting within 7 days of its constitution, if possible. Completion of within 80 days, extendable 330 to avoid unnecessary delays and potential liquidation. So times they have given only upper caps. It doesn't mean we have to conduct on that day. Prepone. The maximum date, if at all they told 180 days, if at all you completed within 90 days, then you are doing the CIRP as also fast track mode. Maintain independence and integrity. IP must act objectively, professional competence, and avoiding the conflict of interest. Conflict of interest. Comprehensive information. Whenever you are verifying, and this information to be included in information memorandum, write it in a book. Later on, all these are to be collated and mentioned in the information memorandum. Prepare a detailed and accurate information memorandum containing all relevant financial and operational information to enable potential resolution applicant to formulate a viable plans to be prepared. Not only that one, due diligence on applicants. Conduct a thorough due diligence to ensure prospective resolution applicant meet the eligibility criteria for 29A of the IBC. So 29A to be fulfilled. And not only that one, transparent communication. Ensure transparent communication and a timely disclosure of the information to all the stakeholders. Because otherwise, they are in a worry mode. Or when my funds will get, and especially the committee of creditors. And for the committee of creditors, what are the best practices they have to adopt is active participation. Members of the CIRP should participate in all meetings and deliberations, either in person or via electronic means, to make informed and timely decisions. That is also required. And focus on feasibility and viability. And evaluate the resolution based on the feasibility, viability, and ability to maximize the corporate data's asset valuation, rather than focusing solely on maximizing the recovery for financial creditors. This is also they have to take care of and exercise commercial wisdom judiciously. Even though the right is there, and nobody should encroach in the commercial wisdom of, but if at all they are not following the guidelines or regulations, then the commercial wisdom is not available to the financial creditor. In most of the cases, the commercial wisdom of a COC is not accepted by the adjudicating authority. While the commercial wisdom of COC is given paramount importance and generally not subject to judicial review, decisions should be fair, evidence-based, and ethically avoiding collusive behavior and the adherence of the voting threshold. Ensure all decisions requiring voting, approval of RP, approval of a resolution plan, extension of a CIRP periods, and passed with the correct voting majority as specified under the code. And generally, 66% for the key decisions. Considering the monitoring committee, when approved by the resolution plan, the COC should consider need for monitoring the committee to oversee the effective implementation. Considering the monitoring committee, when approving the resolution plan, the COC should be considered need to monitoring the committee to oversee the effective implementation. That is also required. But whatever the best general practices are there in CIRP is early detection and planning. Yesterday also I told time management and planning are the two crucial important for the CIRP process. Corporate data should regularly financial reviews and identify the potential risk and have contingency plan to address the financial distress early, potentially even avoiding the formal CIRPs. Leverage technology, utilize the digital tools and secure the data sharing mechanism to enhance the efficiency and transparency throughout the process. The technology today that if you adopt it to that particular CIRP, good results will happen in the coming days also. If at all IPs or the RPs trained in artificial intelligence or machine learning or cloud computing or the blockchain technology or the APIs, application program interface, definitely these are very useful in discharging their duties effectively and efficient. Professional and legal counsel. Engage qualified legal profession, whether it's for a transaction auditor or the valuer or the particular legal people, you have to engage the qualified profession to navigate the complex legal requirement and procedures under IBC to avoid procedural errors and delays. All these things are to be verified. Cooperation among stakeholders. So once you are maintain friendly relationship with all stakeholders, whether it is a minority or majority, or whether it is a worker or the key managerial person. If you maintain a good liaison with the people, definitely you will get cooperation from all the people. All parties involved, like this COC corporate data management must cooperate fully to ensure smooth and efficient resolution process, providing access to necessary records and information. This is in brief about what I wish to tell. This is during CIRP. So pre-CIRP is also particularly you provide consultancy services or advisory services. During CIRP also, if some of the RPs are not doing as per the regulation, you can provide the consultancy services to the stakeholders like corporate data or the financial creditor or the operational creditor or the home buyers, etc. Because once they have followed correctly the cases like Akruti, not arised in the NCLT. So even some other people, they are not adhering, they have not followed the particular guidelines of the IBC in toto. That's why this type of problems are arising. So this is in brief about what I wish to tell. The pre I told, during I told, tomorrow the last class, the post CIR, the post CIRP. What are the areas to be looked into by the particular the resolution profession? That also I will discuss. So with this, I'm concluding today's discussion. And any doubts and clarifications are there, sir? Madam? Any doubts and clarifications and any areas to be discussed? Hello? Sir, tell me, sir. Any areas, any doubts, any clarifications? So if there is no clarifications, I will wind up the class today. And tomorrow also, we will meet by 2 o'clock to 5 o'clock. And tomorrow's class is on the post CIRP. That is once that the post CIRP also, what is the best practices that are adopted, that also I will discuss. So thank you very much and good night to all. Sir.
Thank you, sir. Thank you.